Good evening, everyone, and a very warm welcome to you for this particular webinar hosted by the MDU. I'm Michael Devlin. I'm Head of Professional Services, and I'm not Head of Liaison here at the MDU. And I have two senior colleagues with me who will be doing the presentation. We've got Dr. Ed Farnan and Dr. Sarah Jarvis. And we'll be concentrating on complaints and also looking at complaints to the Medical Council as a subcategory of that. Just a couple of housekeeping points. The first of these is in relation to questions. Because of the nature of webinars, we do ask that you put your questions into the particular question area, which you'll see on the right-hand side of your screen. Is a question mark, and if you just click on that, it should open up a little text box. If you can keep your questions reasonably short, if possible, and if you can get them in as early as you can. Just also to let you know that there will be a certificate of attendance, which you will get afterwards. We will be recording the presentation, so if you know colleagues who might have missed it, who might want to see it, then please do get in contact with them, let them know. They can find it on our website quite easily, and the website is themdu.com/Ireland. We will also be holding polls as we go through the presentation. Ed, who will be taking us through it, will have holding slides up, so it'll be very obvious when the poll questions are coming up. So please do try and answer those as quickly as you can. It's really good, it's interactive, and we get a sort of sense of what you're thinking as we're going along. So without further ado, I will hand over to Ed, and then you'll see all three of us again at the end for a question and answer session. So Ed, across to you.
Thanks, Micah, and good evening, everyone. As Mike says, this is a presentation really on complaints in general, and then towards the end we'll also talk about complaints to the Medical Council, which is obviously the thing that I suspect concerns doctors most. So in terms of what we'll cover, I think what we hope to do might be self-evident sometimes, but maybe not always, is how to recognize a complaint. What should we do when we receive a complaint? What steps should we take to respond and investigate a complaint? And as I say, how to plan for a meeting with a complainant, which again is something which I think causes a degree of anxiety sometimes. And finally, what will happen if a complaint does reach the Medical Council? I think the important thing to recognise at the outset is that complaints are stressful and they are time consuming, and they're stressful for everybody involved. They're stressful for patients. Most patients, and I emphasise most rather than all, but most patients really don't want to be in a position of making a complaint. It's a sign, it's certainly in their minds, that something has not gone as well as they would have hoped. So it's stressful for the patient, certainly stressful for the doctor being complained about. When you go into work in the morning, your intention is to achieve something positive for your patients, to help them, to treat illness, to ease suffering, and so on. And if you find that somebody has felt the need to complain, it's enormously stressful for a doctor, irrespective of whether the complaint has any merit. And it's also stressful for the person who's investigating the complaint. And certainly if you're a doctor in a management position, that may be tasked to you, and you're dealing with people on two different sides where both parties are stressed and upset by the process, and it's very stressful then for you to try and manage that. So Mike mentioned that we'll be maybe holding a few polls as the session goes on, and the first of these was really to ask, just from your perspective, what is the most common cause for complaints, or what was the most common cause for complaints in 2020? So hopefully you'll be able to see the questions as they come up. And this is perhaps just a chance for me, just while there's a short break, to remind you, perhaps if anybody has joined slightly late, that this session will be recorded, and a copy of the recording will be available on the MDU website, which you can review if you have to leave early, or which you can pass on to colleagues if there's anybody who's interested. So we're getting some votes in. If I just hold on for a few moments to see. How we're doing there. And perhaps if we close the poll now and perhaps show some results. And it would appear that, you know, amongst this audience, 79% of you think that ineffective communication is the most common cause of complaints. 16% say a lack of access, 5% say a perceived lack of respect, and actually nobody has felt that ineffective care is a reason for patients to complain. So if we move on, we have some figures from the HSE. These are figures from 2020, which are the most recent ones which we have published. The 2021 figures not available as yet. And safe and effective care, in fact, was the most common cause for complaint in 2020. Communication only 11%, although I suspect in reality, communication is the main cause for complaint in 11%, but communication is likely in my sort of experience to come into a huge number of other complaints as a subsidiary issue. Access, which we felt was likely to be an issue, certainly is, and that is in 34% of cases, and then other issues making up a smaller proportion. In terms of how that compares with previous years, in terms of the overall numbers, about 15,000 complaints in 2020, quite a significant drop from the previous year. I just wonder if that was partly the impact of the pandemic. 2020 was the first year of the pandemic, obviously. I suspect that there was a huge amount of goodwill towards doctors at that time. Whether that continues to be reflected in the number of complaints remains to be seen. That may well just be a COVID-related blip in the early stages of the pandemic, when there was that amount of goodwill, when patients understood that, you know, doctors were working under a huge amount of pressure at the time. Sadly, I suspect that that goodwill may not continue to the same extent. So looking at the sort of the statutory framework in terms of complaints, certainly complaints made to public bodies and the HSE, and one of the things we say is what is a complaint? The Act specifically defines a complaint. It says that a complaint is something made under the Act about any action of the executive or a service provider working for the executive that it is claimed doesn't accord with fair or sound administrative practice, and which adversely affects the person by whom or on whose behalf the complaint is made. In reality, I mean, that's fairly vague wording. It sounds quite specific, but in real terms, it pretty much means anything can constitute a complaint. The important thing is that we can recognize it. In terms of who can complain, well, the patient clearly can complain, but anybody else acting on their behalf, so somebody with legal authority if the patient's unable to act for themselves, or close relative or carer, or anybody acting with the patient's consent, can make a complaint. The Health Act says that complaints should be investigated and responded to if they're received within 12 months of the events that caused the concern, or 12 months of the date on which the patient becomes aware of the events. So you may see a patient tomorrow. That doesn't mean that the patient's limited to a complaint within the subsequent 12 months. If, for example, the patient doesn't become aware of a possible missed diagnosis for another 18 months from now, then they've got 12 months from that point in which they can make a complaint. And in any event, the complaints can be set, the time limits can be set aside at the discretion of a complaints officer if they think that it's reasonable to do so. So it's our view that we should try to respond to complaints even if they're outside that 12-month period, if it's practicable. And if for any reason you're considering not responding to a complaint, we would suggest that you seek advice about this, and we're more than happy to discuss that if that's the case. In terms of what's excluded from the complaints process by the Act, there are a number of things, including, for example, a matter which is the subject of legal proceedings, or if an investigation of the complaint could prejudice another investigation which is simultaneously being undertaken by the police. So criminal matters, for example, under investigation, are not likely to be included within the complaints process. The Act also talks about various procedural and administrative matters about the process. So we defined the complaint in some form in the last slide, but in reality, recognize a complaint can be more difficult than we might think. But in practice, essentially any patient can say that they're not happy about the service that they've received. The question really is, at what point do low-level concerns or grumbles trigger your organization's more formal complaints procedure? Sometimes the simplest way to do that is simply to ask the patient. And if frontline staff, whether those be clinical staff or administrative staff, are trained to respond to all expressions of unhappiness, in particular these low-level grumbles, and if they can respond with an apology or with the question, how has this affected you, or what can I do to put it right, then many verbal complaints are likely to be dealt with successfully, quickly and informally. And the HSE complaints handling policy calls this approach the point of contact resolution, and it requires it to be completed within 2 working days. And clearly the more complaints that we can settle at this, which is the earliest stage, the less time we'll then need to spend responding to more formal written complaints. What I would say is that even if a complaint can be resolved informally in this way, you should still make a formal record of it and keep that locally, including what action you took or any learning arising from that. Because if the complaint then, or rather if the patient then comes back to you with additional concerns or saying that you haven't dealt with it appropriately, you've got that formal record of what you did to fall back on. To some extent, doctors are often worried that patients, when they do make a complaint, they're doing this as a preempt to some further action, such as a clinical negligence claim. But in reality, what patients tell us is that in a large proportion of cases, what they're actually complaining about is in order to receive simply answers about what happened in their care, where they maybe feel that something hasn't happened as expected. And this is supported by the fact that the majority of complaints about doctors relate, at least in part, to communication issues, even if that's not the main focus of the complaint. Patients are also strongly motivated by a desire to prevent another patient from having the same experience that they've had in future. So understanding what drives a patient to complain means that we can tailor our complaint responses to address those motivations, even if they're not explicitly mentioned in the complaint. One of the things we can do to hopefully prevent complaints to some extent is a careful consent process and management of patient expectations about treatment or how symptoms might be investigated. And this can help reduce the risk of complaints if there's an unwanted outcome. So again, it comes back very often to communication at the outset. And while concerns about clinical care might be what the patient is complaining about, the reason that they choose to complain may be because of problems with communication, such as perhaps not adequately explaining what was involved in carrying out the treatment, a failure to acknowledge symptoms, or just not listening or giving the impression of not listening, are also themes which within clinical complaints can be relevant. A final thing is that a perception, and I emphasize the word perception here, of a lack of courtesy or a lack of human empathy, or a perception of rudeness or indifference, a perception of callousness or aggression, can often form part of the complaint and can even be the sole issue. The goal of the complaints procedure is really to try and resolve the issues in the complaint to the satisfaction of all parties. So, to your satisfaction as well as to the patient's satisfaction. We would suggest that all of the staff who are directly involved in the treatment or in the consultations in question, or who are the subject of the complaint, should be asked for their comments and their observations on the complaint. The fact that somebody may have left an organisation shouldn't necessarily prevent you from trying to contact them as part of the complaints investigation, although in practice that might not always be possible. But making that effort to contact somebody shows that you've been thorough in your approach. And when analysing a complaint, it can be helpful to ask yourself a number of key questions. Firstly, do you understand what the complaint is about, and have you identified all the elements contained within that? Does the complaint involve other organisations apart from yours? And if so, do you need to share it with that organisation to try and coordinate a response? If the complaint concerns one or more members of staff, will you need to interview or take an account from each of them? Having reviewed the complaint, are there any relevant organisational policies or procedures which might include, for example, clinical guidelines or protocols if the complaint is about clinical care? And finally, does the complaint require a degree of independence in the oversight or in the review? This is important because if a complaint is about you, and if you're the person who investigates it and responds without anybody else being involved, it can give the impression that you've been less than objective and that you've to some extent marked your own homework, for want of a better phrase. Asking a colleague to be involved can avoid that suggestion. So our second poll question really is, are you concerned about apologising to a patient when responding to a complaint? We know that apologies sometimes do cause a degree of anxiety, and some doctors do ask us whether it's appropriate to apologise and to use a particular form of words. So if I can leave that there just for a moment and ask if you can respond to the poll. So again, we've a significant number of people have voted there, and about essentially it's 3 to 1. 75% of people are saying no, they're not overly concerned about apologising, but a small proportion, but a significant proportion say yes, and that certainly reflects our experience that doctors often are slightly anxious about including an apology because of what they fear might be the implications of that, and we'll come on to discuss that in a bit more detail. So if we come on to responding to complaints, what we would suggest is that a comprehensive account of your involvement in a patient's care, including an explanation of what you did and why you did it, will often address the first point that we spoke about earlier, about the patient getting answers. And including your reflections on your involvement, and in particular what you might have learned and how your practice will change if that's the case, will help address the second point about future care, both for the patient and for others. And those are two vital elements in any good complaint response. On receiving a written complaint, the organisation's complaints officer should generally contact the complainant within 2 working days with an offer to meet with them, along with a clinical director or another senior member of staff. If the complaint can be resolved at that initial meeting, then a letter can be sent to the complainant summarising the process, and the doctors involved may be sent a summary of the concerns that were raised. And the HSE calls this an informal investigation. If the complaint is not settled after that meeting, or if the complainant declines that initial offer, a letter acknowledging receipt of the complaint should be issued within 5 working days, and then that triggers the more formal investigation process. There are timeframes for that. A written response should usually be sent within 30 working days. That's not always practical for various reasons, so if that can't be achieved, then the complainant should be updated at regular intervals until that final response can be sent. Within the response, we would suggest by starting with an apology that the patient had cause to complain, and explain how their complaint has been investigated. So what steps were taken to investigate, who was involved, and so on. This is important to get right. Those opening sentences really set the tone for the whole complaint process, and where possible, they really should be as conciliatory and reflective as you can make them. Even when you don't fully understand what may have prompted the complaint, or when you feel it has no merit, it certainly can be helpful just to acknowledge that the patient is unhappy. And that sort of sensitive initial couple of paragraphs is often very important. You can then move on to give a factual account of what happened. That should be written really with fairly close reference to the clinical records. And you might also want to refer to, for example, any relevant guidelines that you followed. It's perfectly reasonable if there's more information, for example, from your own recollection or your usual practice, to include that, even if it's not specifically documented, if that helps you explain what you did and why you did it. And this kind of is the part of the response where if there is a misunderstanding on the patient's part, you can gently correct any factual inaccuracies in what they recall. And that gives you a good framework to then, having given that factual account, to go on to address the specific issues. If a complainant raises concerns about more than one aspect of their care, it can be very tempting to try and focus on either the biggest issues or the ones which are easiest to answer. But you should try and make sure that all of the concerns are addressed, either by you or, if more appropriate, by someone else within the organisation. Simply because not doing so might increase the chances of the patient returning with the same concerns after they receive your initial response, perhaps even more unhappy than they were first time around. Complaints mentioning a doctor's attitude or their approach to a patient can be particularly difficult to address because the patient's experience of that consultation is unlikely to match your own recollection. You know, the patient will say, Dr. X was rude. Clearly, Dr. X is unlikely to have intended to be rude and didn't feel they were being rude. But what it can be helpful to do in such a situation is to acknowledge the patient's upset and apologize for the distress that they've experienced, and say, just, you know, if you were rude or if you appeared rude, that certainly wasn't your intention. I mentioned reflections on that slide. I'm going to skip over that because we will touch on that in slightly more detail later. We mentioned apologies in the poll, and including apologies in the complaint response can cause doctors to be concerned that it might be an admission of wrongdoing or even an acceptance of liability, but this is not the case. In our experience, apologizing for an upset and saying that lessons can be learned is often helpful, and lessons often can be learned even in cases where the care was exemplary. If we can just maybe look at a scenario, and this is the type of complaint that we will often see and that we're often asked for advice about. And if you cast your eye over that letter or that sort of wording from a patient, ask yourself, how would that make you feel to receive that? Because emotive and angry letters can understandably, in my view, arouse emotions in the doctor, sort of the so-called second victim of the complaint, the patient being the primary victim in a sense, but the doctor being the second victim because of the impact the complaint has on them. But those emotions are generally unhelpful when it comes to composing a considered response. Recognizing that in yourself and then moving on, hopefully, from the initial emotional response can help you to draft a more measured response. The request here for a response within 2 days and the threat of press action might make you feel pressurized into producing a hasty response, but it's important to take time to involve the complaints team, to produce a measured response, and where appropriate to take advice from your defence organisation. This is an example we've given of perhaps how not to respond. It's obviously tongue-in-cheek to an extent, but sometimes doctors do ask advice from us as to whether they can end a professional relationship with a patient simply because the patient's made a complaint, particularly if the complaint is without merit in the doctor's view. It's unlikely to be helpful to do that. What's more appropriate generally is to respond much as we said we should do, in a measured way, with a factual account and letting the facts speak for themselves. So the first thing that should happen, as we said, is that there should be an initial acknowledgement letter sent. Where possible, you should give some form of timescale, but that should be realistic, enough to allow you time to investigate, to draft the response, and to take advice where necessary. You should consider any potential delays which might occur. That might be because some of the people involved are going on holiday or about to do so. And if there's any information that you might need to gather from other sources before you respond. If you can't respond within your initial timescale, then update the complainant. Again, it's all about managing expectations. The doctors involved in the process should, where possible, write a factual report which can be included in the overall response. And I would suggest that the doctors do ask to see the letter before it goes out, simply to ensure that it is factually correct and reflects their views. You can start then by outlining the specific complaints that will be addressed in the response and explaining how they've been investigated. So what steps have been taken, who was involved, what other sources of information have been sought. And then essentially to see what the findings of your investigation were. Again, in this case, it allows to some extent these facts to speak for themselves and to show that the factual account provided by the patient in the complaint was not necessarily accurate. You can offer an apology. I mean, if it was the fact in this case that the patient was not updated about the possible delay that they might experience, then you can apologize that that was the case. And also include evidence of learning, saying that, in future similar situations, you'd be more proactive about ensuring that every patient is updated with delays. And this approach works for administrative matters like late appointments, but also it works extremely well in clinical scenarios, just the same way. And then, as I say, you can include your action plan as to what's going to happen in future in similar situations. I mentioned earlier about the possibility of meeting with a complainant. It can provoke a certain degree of anxiety, but in reality, it can be particularly helpful to have a meeting if it's hard to fully explain what happens on paper, or where you simply think that a patient will understand matters better or prefer a meeting to a written response. But it can also be helpful to try and resolve complaints that remain ongoing after the written response has been provided. Where that's the case, where you think a complaint remains unresolved and you do plan to meet with the patient, it's important to sort of think about the following things as outlined on the slide. So try to determine which matters remain in dispute or unresolved, because this will hopefully allow you to set an agenda and to allocate appropriate time to make sure that the meeting is efficient. Ask yourself, is the nature of the disagreement something that could be resolved through discussion or further investigation? Or is it that the complainant simply doesn't trust or believe the response that you provided? Identifying areas where agreement may not be possible and managing those expectations at the start of the meeting, again, might help you to use time more effectively and more efficiently. Ensure in your own mind, and also for the benefit of the patient, who will need to attend the meeting. So are all of the relevant staff available? Does everybody need to attend, or will that give the impression of the patient being outgunned? But do you have someone who can take minutes? Is there somebody ideally independent of the process available to chair the meeting? And does the patient wish to have a supporter present? All of these things are likely to sort of ensure that the meeting is more efficient and more effective. I mentioned the Ombudsman there. The Ombudsman does have powers to investigate complaints from patients who have been treated by a public body, which includes public and voluntary hospitals and private nursing homes. And the Ombudsman will consider any concerns which, if upheld, might amount to maladministration on the part of the public body. The Ombudsman cannot investigate complaints relating solely to clinical care or complaints arising from private medical care, regardless of where that's been provided. I should say that my experience generally is that the Ombudsman does not tend to get involved in cases which come to the MDU, presumably because the cases which are largely clinical don't fall under their remit. Patients are much more likely to escalate concerns to the Medical Council rather than to the Ombudsman. That's a difference from other jurisdictions, and I'm sure Mike and Sarah later on would confirm that the Ombudsman in England and Wales, for example, as well as north of the border where I'm based, is much more willing to get involved in health-related cases. I mentioned reflections. I would suggest that all but the most minor complaints should be discussed in a formal setting, such as a significant event review. It can be helpful to have somebody independent involved in the complaints investigation, but similarly, if you're going to reflect on a case, somebody independent of the process, but somebody who knows you can be helpful. That's because they can be frank with you if something's gone wrong or if something could have been done differently, but also because they know you and will recognize that if this is something where something's gone wrong, it's likely to be a blip, and they can provide reassurance from your perspective. Where possible, a response should include an explanation of any learning points for the reasons that we've given, and that should be as specific as possible rather than a generic statement such as lessons will be learned. Not all complaints will result in learning points. In some circumstances, it can be helpful to explain that you've looked at things and why you think a different approach wouldn't be possible. The importance of including reflections is not only because it stands as evidence of reflective contemporaneous practice, it would also be useful for that reason if the matter is escalated. For example, if the complainant then goes to the medical council. So in summary, from the perspective of local complaints, they're unfortunately unavoidable. They can be disheartening, but having a proper process and a complaints procedure will allow you to have an efficient way of dealing with that process and gives you a structure in which to respond. Complaints often have a degree of communication at their heart, but even for those which are purely related to clinical care, if something does go wrong, the patient is entitled to a prompt and frank explanation, and you should be as open and transparent as possible. I said we'd move on then to discuss the medical council and complaints which reach that jurisdiction. We thought it would be helpful because a small number do fail to get resolved at a local level and are then escalated. But in addition, some complainants bypass local processes and complain first to the medical council. You'll know that that's the regulator of the profession and that it derives its powers from the Medical Practitioners Act of 2007. Its purpose is to protect the public by promoting and better ensuring high standards of professional conduct and professional education, training and competence amongst doctors. There are about 21,000 doctors registered with the council, but only a tiny number of these every year have an adverse finding against them, which is referred on to the High Court for confirmation. But it's important to recognise that being told that a patient has complained to the medical council is enormously stressful for any doctor. So our final poll for this evening, very quickly, to what extent are you concerned about facing a medical council investigation? So again, if you can contribute to the voting, to the poll, we'll have a quick look at those answers and then hopefully talk a little bit more about the process, just so that there's maybe an understanding. And again, for those who may have joined late, a reminder that this webinar will be available on our website if you want to go back and catch up on things you missed at the start, or if you have to leave early. And again, there's about a significant number have voted now. Very few folk are not concerned. Some people are not very concerned, some people very concerned, and some people somewhat concerned. Again, a fairly even split apart from those who aren't at all concerned. And again, irrespective of whether you think it's something which is likely to happen to you, a medical council investigation and receiving a letter or an email from the medical council will inevitably cause a degree of anxiety. So very quickly to look at what the grounds for complaint are. Just to clarify that patients certainly can complain to the medical council, but the medical council also receives complaints from other doctors, other healthcare professionals, from the police, from the HSE or from other employers, and the medical council itself can become the complainant, for example, if it learns of something through the press. It can be about clinical matters or clinical competence, but also about your conduct in a non-clinical context. There is a guide to professional conduct and ethics which the medical council publishes. If you're not familiar with it, it's available on their website, and I would certainly suggest that you familiarise yourself with that because it outlines essentially the standards which they expect. The categories are as listed on the slide there. Professional misconduct includes conduct considered to be disgraceful or dishonourable and can include things like criminal activity or sexual misconduct, but also can include conduct which falls seriously short of the standard expected amongst the profession. Poor professional performance means failure to meet the standards of competence that can be reasonably expected. Contraventions of the Act would, for example, be practicing while not on the appropriate register. Where there has been a previous investigation, and if that was concluded with conditions or undertakings, that would be a failure to comply with those. And if a doctor has been convicted either within the state or elsewhere of an offence which would be an offence within the state, that can trigger an investigation. This is a slide just breaking down the steps. This is taken from the Medical Council's own website. And just to go into that in a little bit more detail, the first step of any investigation is with the Preliminary Proceedings Committee, and it will consider all complaints made about doctors registered with the Medical Council, but only those falling within the Medical Council's remit will go on to be investigated. If that's the case, then the current legislation allows the Medical Council very little discretion as to how it can then proceed. In most cases, the PPC will appoint a case officer to assist in the investigation of the case. And the first that you will know about a complaint is likely to be a letter from that case officer. This generally explains that the Medical Council has received a complaint, and they will enclose a copy of the complaint with that. The letter will also explain the processes and say, for example, that the PPC will be considering the complaint at its next meeting, which are usually held once a month, and it will invite you to provide any comments that you think that they should consider. What I would emphasize here is that there's no obligation at this point to provide them with any information about the complaint, and we would certainly advise in most cases that you don't comment at this stage. Sorry, I beg your pardon there. The reasons for this are that there may be a very tight deadline in which to provide comments, and it might mean you respond in haste before you have any or all of the relevant information. The letter that you do send back does become part of the formal investigation, so it's important to ensure that it is entirely correct. There will be an opportunity to respond later, even if you don't respond at that early stage. What happens next is very much dependent on the nature of the case, but we would certainly suggest that you contact your defence organisation and provide us with your comments so that we can guide you through the next steps. What will generally happen is that the PPC will write again after their initial meeting, and again may invite you to comment, but may also require a comment, in which case you must respond. But providing us with all of the information at an early stage means that we can often prepare a response ready and have one ready at the point where a response is required. The PPC will consider any comments that you might make and will gather other information, such as information from the complainant, from the medical records, and in some cases, particularly clinical cases, an expert opinion. What I would say is that under the current legislation, this is an extremely lengthy process because they only meet often once a month and things get batted back and forth once a month. At the end of the investigation, they will either refer the matter on to a fitness to practice committee or conclude it with no further action, or with a referral to another body such as the HSE, or for a performance assessment, or for mediation if they think that the matter could be resolved that way. Most cases, I have to say, at this point are resolved with no further action. To give another case scenario, a patient admitted after an unwitnessed fall, was on an anticoagulant, at the point of admission was fully conscious and well, but soon afterwards their coma scale started to drop, and that progressed over a period of time. Turned out that they had a subdural and required intervention. They did have a reasonably good outcome, but the family complained, particularly again because, as we see here, they felt that the doctor's manner had been brusque. The hospital responded, the family were unhappy and escalated matters to the Medical Council. The doctor contacted his defence organisation and explained that he had really had peripheral involvement for much of the time that they were complaining about. He certainly had peripheral involvement in the complaint response and hadn't seen that before it was sent. This gave us the opportunity to prepare a much more detailed response regarding the doctor's involvement, in which he apologised, explained what his learning points were, and that was submitted to the PPC, which did close the case. And as I say, that's fairly typical of cases which reach the Medical Council. Most in my experience don't go beyond the PPC. For those that do, it's probably worth knowing that the Fitness to Practice Committee hearings will generally take place in public, unless the inquiry concerns a doctor's health. They are adversarial, with the doctor acting as the defendant and the Medical Council as the prosecutor. It's worth perhaps knowing that the criminal standard of proof applies, so it's essentially beyond reasonable doubt, which is a different approach from, for example, the UK's General Medical Council, where a much lower standard of proof applies. It's likely to take months or even years for a case to reach this stage. A number of sanctions are available, ranging from simply providing advice to a cancellation of the doctor's registration, and most of these sanctions will need to be confirmed and ratified by the High Court. The choice of sanction will be influenced not only by the seriousness of the allegation at the time, but also and importantly by mitigating factors, which can include remediation by a doctor, such as insight or further relevant training or CPD. And for this reason, we advise that from the earliest stages, doctors do reflect on concerns and take what steps they can to address any criticism, even if they don't necessarily agree with it. Early evidence of reflection can significantly reduce the severity of a sanction and could even reduce the chances of a matter being referred on. Finally, just to say a couple of things on the horizon. The guide to professional conduct, which I mentioned, is up for review. The MDU has submitted comments to the consultation. We think that there are significant changes required, either to reflect other changes in legislation which have occurred, or which are needed simply to introduce clarity for the benefit of doctors. There's also the Regulated Professions Act. Most of the provisions of that act relevant to the Medical Council and complaints have not yet been commenced. But the hope is that when those provisions do come into law, that there will be a slightly more streamlined and less time-consuming process for doctors. For example, the CEO of the Medical Council will be able to screen a complaint and decide if it is frivolous or vexatious and dismiss it at that stage. So essentially to say, this is the important thing, is to recognize that Medical Council investigations are stressful, hearings are stressful. Finding yourself subject to an investigation can take an enormous toll on your personal life and your professional life, even if the outcome is in your favor. If you are notified that the Medical Council has received a complaint, irrespective of your view of the complaint, and certainly if you're an MDU member, you can certainly seek our support and advice. And finally, just to flag up, I mentioned that the webinar will be available on our website. There are details there about how you can contact our membership department and the advisory team, and also information about the website, which is the mdu.com/Ireland. This webinar will be available for viewing again, but there is also some specific advice relevant to Ireland about complaints handling, about the Medical Council, and about other issues such as raising concerns, dealing with inquests and the like, in the Irish jurisdiction, all on that website. So without further ado, I'll invite Mike and Sarah to join me again.
Ed, thank you very much for that really interesting, informative and incredibly helpful presentation. I was struck really by the breadth of issues that the HSE see in an average year. And we've got some questions to go through, so if you don't mind, I will
Sure.
pass these to both of you to have a think about. We did touch on apologies, and that's clearly something that still is a concern. Someone has noted that they are anxious about apologising to patients, and they say that some colleagues, perhaps some senior ones, are advising caution about giving apologies because it could be seen as an admission of liability. And they note that if the matter then becomes a civil claim, does that really make things more difficult to defend if you've offered an apology? So perhaps, Sarah, if I could start with you for your thoughts, and Ed, anything you want to add also.
Thank you, Mike. I think it is sometimes a fairly widely held misconception that making an apology is an admission of liability, and certainly the experience here at the MDU is that generally that is not regarded as being the case, and often you are apologising that someone has suffered distress or has been upset by something, and so our advice is that you should really apologise where it is appropriate for you to do so, and often that will help to diffuse the complaint and may stop other processes from carrying on.
Yeah, I agree. I think an apology will often diffuse things. It's often what the patient is wanting to hear, is that you're sorry for any upset, distress that they've experienced. It's not saying that you've caused them any harm. Complaints and claims are quite distinct and separate processes. A claim will essentially be decided on the facts of the events as they happened. If a patient has come to harm, and if the clinical care was negligent as determined by a court, then the claim will succeed, irrespective of an apology. Similarly, if there was no negligence, and if expert evidence supports the doctor's clinical care, then the fact that you've apologized for some upset or distress is not going to affect the outcome, which is that the claim is, as is the case in most cases, will be successfully defended.
I think perhaps it's helpful to mention as well about the nature of an apology, that generally it should be unqualified. And I think we're often very careful when we review complaint responses. When somebody has said that they have been very upset, if a doctor then says, "I'm sorry if you feel," rather than "I'm sorry that you feel." And I think sometimes sort of reflecting back to the patient that you recognise the distress that they've had, that again can be very powerful at diffusing the situation and making sure, as I say, that the apology is appropriate, as you know, regarding what's actually happened.
Yeah, that's a very good point, and thank you for bringing that up. The next question, I suppose, is a little bit of a technical one. So, Ed, if you don't mind, I'll sort of come to you first with this. And the question is regarding time limits for complaints, and does the 12-month time limit apply to cases which go through the civil court process? And someone speaking from their own experience here. And rather sadly notes that they were never given the opportunity to respond to the complaint whilst the claim was ongoing. So that 12-month time limit, and does the supervening legal action change that?
I think in practical terms, there may be circumstances where you can't respond to a complaint because there is another process going on, and I mentioned that during the talk, is that if there are coexistent legal processes going on, such as a claim, that may mean that a complaint shouldn't be responded to until that matter is resolved. That might mean that you have to put a pause on the complaints process, which means that you don't respond until after that's ended. That doesn't mean that you shouldn't respond after that's ended. It doesn't mean that the clock starts ticking and then the complaint is to some extent time expired. If you're able to respond, and if it's practicable, it's often appropriate that you do then respond if you can. Unfortunately, if in this case it sounds like the doctor didn't get a chance to respond to a complaint, and that may well be what triggered the patient to escalate matters to a claims process. If a complaint had been dealt with, and if that had been done sensitively, and if that had resolved the patient's concerns, they may well not have proceeded to sort of take things further.
Thanks. So, Sarah, I think we've got lots of experience, haven't we, that if someone does respond promptly and fully to a complaint, that often helps to resolve things. And also people who do still consider claims that are slightly out of time, again, that's really appreciated by patients and their representatives.
Yes, I think that's right, that that there are timescales that are in there, but actually if dealing with a complaint that is technically outside the 12 months might stop someone from going elsewhere to look at another process. In general, it's helpful if you can resolve something at the, I suppose, at the lowest level possible, then that's generally beneficial for the patient, but also for the clinicians involved in that as well. So I think that sort of recognizing that whilst technically something might be out of time, actually making a good response might stop other processes from starting.
I think the other process which I think is particularly relevant in that context is the medical council, which doesn't have a particular time limit.
Yeah, absolutely. No, that's a good point. Thank you. Another question here, and this I think probably goes back to, because it's one of the first that was asked, it goes back to the early part of the presentation. And I think looking at communication, and the question is that doctors obviously are working under time pressures, time is short. And what's our experience of doctors who either haven't safety netted or haven't asked the patients if everything is clear to them? So very much a question focused on those communication skills and making sure that the doctor is making herself understood.
Yes, that's definitely something that we would recognise. There is, always a huge, I suppose, doctors' time is the biggest resource limitation that we see in healthcare, and I think sort of trying to get into the habit of making sure that you document to a reasonable level, that you are specific as you can be in your safety netting advice. So rather than saying, if symptoms of dehydration, bring little Johnny back to see us again, it may be better to say, if the child hasn't passed urine by 10 o'clock tonight, you need to contact so and so. So I think often being as specific as you can be with safety netting is helpful. I think sometimes to remember other resources that can augment what's gone on in a consultation as well. So sometimes patient information leaflets can be really helpful. Sometimes our colleagues can be very useful, very experienced nurses in the clinic who've got experience of a particular condition, that after a consultation's been given where a patient's got a diagnosis, that perhaps there's somebody else who can reinforce what's been said, provide leaflets, details of support groups. And I think it's often a case of getting your own system of documenting everything properly and knowing what you need to get across. But I think certainly we recognise that it is challenging, and often it's the case that it's not that the doctor hasn't given information, it's that they haven't documented that they've given information, and that again is a real challenge, because of course it's always helpful if there's a complaint or a claim to be able to demonstrate exactly what happened in that consultation. But it is all a balancing act when your waiting room is full of other patients as well.
It is, yes. Thank you very much indeed. Got a topical question here, as you might expect, 2 years into the pandemic, 2 years plus into the pandemic. And someone has noted that during this period, some patients, and by no means all, but some patients are becoming increasingly verbally abusive to both admin and clinical staff. And the doctor notes that they find it really difficult to sit down and respond to these complaints in writing when they know just how abusive the patient or their relatives have been. But their concern is that some of these complaints might go to the medical council. And do we have any idea how the medical council might view this type of complaint? So maybe, Ed, if I can go to you first this time.
Sure, and I said during the presentation that there were fewer complaints in 2020, and I wondered if that was a reflection of a certain amount of goodwill towards doctors at that time. My impression is that goodwill is a thing of the past, unfortunately. And certainly our impression is that patients are becoming much more verbally aggressive and abusive towards doctors. And I think if you look at the popular press, the general public, by the look of things, is becoming more aggressive and abusive towards other service providers. It's not just doctors who are on the receiving end of that. I think the other thing I mentioned during the talk is that it's important to recognize when you receive a complaint, your own emotional response to that, and to try and give yourself a little bit of breathing space before you respond. To respond in haste in these situations is likely to leave the complainant remaining dissatisfied, and it's also likely to reflect badly on you if the matter does escalate. So, taking that time to sort of pause, reflect, think about what you're going to say before you say it, and then responding. That means that if the matter does get as far as the medical council, they'll see that you're the person who has acted proportionately, responsibly, sensitively, and in a reflective and conciliatory way. And the matter's not likely to go any further in that situation if they can see that you're the person who has dealt with the issue appropriately, and that it's the complainant who is being unreasonable. If you get an unreasonable complaint, and then if you respond unreasonably, it's not likely to be looked on nearly as well as a measured response.
Thank you, Ed. Sarah, any thoughts on that one?
Yes, I mean, I think the important thing to recognise is the emotional response that receiving a complaint can place on a doctor. And one of my colleagues always refers to the HALT acronym, H-A-L-T. So dealing with things if you're hungry, if you're angry, if you're running late, or if you're tired, things can often take on a resonance that perhaps they don't after you've had some supper, a good night's sleep, and gone back to look at it at the next morning, and hopefully been able to pick up the phone to somebody at the MDU to sort of give you some helpful starting points as well. So I think that's important. And of course, as a society, it's very easy now to make a complaint. Years ago, people would have to go and buy a pad of writing paper, write a letter, post the letter, wait for a response. But I think we're increasingly becoming a more we expect things to be done in a very quick manner, and it's very easy to fire off a complaint from your phone, you know, whilst you're still in the waiting room almost, which can cause problems. But I think as doctors, we often want to make a response to get things sorted, but I think my advice is that you want to make the best response that you can rather than the quickest response that you can. That's really important.
Absolutely. No, it's quality of response rather than speed of response. I think we've got time just for another quick question, if everyone is happy with that. Here is one that I think is quite interesting. So this is a doctor that's been asked to respond to a complaint, and the complaint is actually about a colleague who's now retired. This particular doctor wasn't involved in the care of the patient at all. And although he or she feels that they can help with a response based on the clinical records, they're a little bit uneasy about commenting on other doctors' actions. And they ask, should other doctors be contacted, or should the retired doctor, I should say, be contacted to provide their own comments? So Ed, perhaps if I start with you again first and then go on to Sarah.
Yeah, I think the short answer is yes, if possible. That's one of the things I touched on, is that if other people need to be contacted, even if they've left the organisation, then yes, if they can be contacted, it may be appropriate to explain to the patient that they're no longer there, that you would like the patient's consent to contact them. But yes, if the other doctor is available, if they can be contacted, then it's appropriate to try and do that. It means that you can demonstrate that your complaints process is thorough and comprehensive, that you've taken those steps. If they can't be contacted, if the patient doesn't want that makes it slightly more difficult to respond in a meaningful way, because really all you can do in that situation is base your complaint on what that doctor has documented at the time. It's difficult to interpret that and to comment on their actions beyond that.
Indeed, Sarah, always difficult this, isn't it? Because you rely on, I guess, the quality of the clinical notes, and maybe that doctor was a friend, and it's sometimes difficult to step aside and do things in a dispassionate way.
Yes, I think that we would all recognise that you do develop sort of very close working relationships, especially in small teams where there may only be a couple of you there, and it can be difficult doing that. I think if we look at it from the perspective of the retired doctor, though, assuming that doctor still has medical council registration, if they're not involved in the complaint response and then the complainant goes on, it may actually prejudice their ability then to defend themselves later on. So I think that, you know, for most doctors, I would want to know if I had retired and I had a complaint that came in, so that I could have some input into that and hopefully, again, minimise the risk of other processes.
Thank you very much. Well, I think it's just a couple of minutes after 8 by my clock here, so just leaves me to thank both Ed and Sarah for the contributions and for an excellent presentation, which I hope all of you have found helpful.